What are the most common reasons divorce and other family law matters end up going to trial?
I would say the most common reasons are custody and big finances. So I wouldn't say if finances are relatively small. So in other words, the difference on child support or alimony is maybe a few $100s a month apart from one offer to the other offer. It's not worth taking it to trial because I let my clients know going into trial, at least on my current hourly rate, they're conservatively looking at $30,000 to do a trial. In fact, I just had this discussion with a client yesterday. He is possibly looking at taking his case to trial, and it's just on financial issues. It's not even on custody. And I said, well, typical financial trial is about 2 to 3 trial dates all day, like 7 hours. And I also let them know, at least here in the greater New York City area, you can show up with your massive briefcases and boxes full of trial materials and everything. You can show up at 9:30 every day, and guess what? The judge is not going to see you at 9:30. They will invariably have their regular calendar, and they will go through their regular calendar of other cases for about an hour or two or more until they get to your trial. And so you will start your trial usually around 10:30, 11:30, and then break at either 12:30 or 1 and come back at 2 or 2:30 and go another couple hours. But meanwhile, the attorney's billing you all day. The attorney's going to bill you from 9:30 until 4:30 or 5 every day. And I also let my clients know for every hour that they spend in court, they are spending at least 1 to 2 hours of billable time for me to prepare for that trial. So obviously one can do the math. If you're there 3 days, 3 times 7, 21, that's 21 hours. If I spend conservatively 2 hours of out-of-court time for each hour in court, that's another 42 hours of billable time. So it doesn't take hard math from there. If an attorney's billing $500 or $600 an hour, to multiply $500 or $600 times 63 hours and come up with a conservative figure on how much that trial is going to cost you. So then if you're only apart a few $100s a month on child support or alimony, you could probably figure out that just from a pure cost-benefit analysis, it's not worth it to go to trial. And if the other side won't budge, then you might as well just give in rather than pay even more to take the case to trial with the uncertainty as to whether you're going to win or not, because trials are not certain on either party's part. People can think, oh, I have a really solid case. The odds are overwhelming that I'm going to win this trial. And then it turns out they're wrong. I've had cases where you take a case to trial and you're right on the facts, you're right on the law, and all of a sudden the judge says, yeah, but in New York, we have what's called equitable distribution, which is another fancy term for what I think is fair in any individual case. And I'm guided, this is the judge speaking, I'm guided by these 16 statutory factors. One of the factors is whatever other factor I want to consider in any individual case and what I think is fair. And so I've had cases where, I feel we're solid on the facts, we're solid on the law, and then we get to trial and then the judge says, yeah, but I think it's fair to give wife or husband XYZ in terms of asset distribution. Oh, well, then you have to discuss with your client, we just spent 30 some odd $1,000 to get to that point. Do you want to spend another $10,000, $20,000 doing an appeal? And maybe you win the appeal, maybe you don't win the appeal. And sometimes you win the appeal and God love it, the appellate court says, we think the party appealing the case is right. And so what we're going to do is we're going to send it back to the trial court so that they can have another trial. And then you have to spend another $30,000 having a brand new trial, possibly before the same judge that you just filed the appeal on. So you have to take all those things into account as to whether you really want to take a case to trial or not. Custody cases are another common reason why people go to trial. And what I do as an attorney is I walk my clients through every single permutation that I can think of to see whether something can be settled. So every single permutation of access time or anything like that, and go over that with the other side, sometimes have four-way conferences if there's no domestic violence issues involved, or if there are, then maybe we can do that with the judge's court attorney in court, and have conferences and attempt to settle the case along the lines of permutations. I even have a case right now where there are alleged domestic violence issues. Yet I had a conversation with my client. Father is otherwise wanting to possibly contest custody at trial. And I said to my client, look, you may or may not be able to prove the domestic violence issues at trial. And if you don't, and the cookie crumbles the wrong way, you could lose the trial and therefore lose physical custody of your child. And so do you really want to run that risk? And she really did not want to settle for any form of joint custody. But I also got her to the point where I had this long discussion with her and said, look, as a practical matter, joint custody issues very rarely come back to the court. Most of the time, those issues are able to be worked out outside of court, either by the parties themselves, or they consult the relevant professionals, the doctors, the teachers, et cetera, to guide them in the decision-making process. Maybe they consult mediators or lawyers to keep stuff out of court, but it almost never comes back to court because somebody is violating a joint custody provision. And joint custody does not necessarily entail oral discussions between the parents. There's a lot of apps now that allow and facilitate communication between parents, such as Our Family Wizard or Talking Parents or Two Houses, where they can have those discussions on the joint custody issues, and it would not entail any direct communication between the parties. So that's number one. Number two, in terms of access time, in the particular case that I just had a discussion with my client on, the father is already getting alternate weekend visits. So he's not going to go back on that to settle the case. If anything, he's going to want more. So I said to my client, look, rather than facing the prospect of losing physical custody of your child, why not, offer a midweek visit or two? Why not offer, some kind of sharing of access time over the summer and on school breaks and on holidays, and try and sweeten the pot as much as possible to get the other side to say, okay, I've gotten what I feel is adequate access time. I'm willing to settle. If that's the case, then, let's see if we can explore every single permutation of settlement, because having those settlement discussions is far less costly than preparing for and doing a trial. So that's what I would say on that issue.